Thank you, Mr. Chairman, for holding this hearing. To the witnesses, thank you for coming. I know that it's inconvenient for you, some of you. It's expensive. You have other things to do. Thanks for being here with us today. Thanks for the service that you give to your country. If you don't mind, I'm going to spend a little time with you, Mr. Parker. Both of us coming from Utah, and we've known each other for a little time. I look at you and I think, okay, here's a guy who maybe has spent a little time on a horse. Knows a little bit about ranching, knows a little bit about farming. I want you to know that I do as well. I grew up farming and ranching. We still have both my family farm and my in-laws have a ranch, and it's deep in our blood, and we appreciate that lifestyle. I mean, it is nothing more American than the family farm or the family ranch, and it's something that we want to protect. Mr. Parker, would you consider yourself an expert on, ranching and farming concerns?
I've been involved in ranching since I was born, yeah. Cattle and sheep ranching, yes, sir.
Well, and you represent a fairly large organization, as I understand, right?
We do 6 million member families in the United States that I'm speaking for today.
6 million. That's a substantial number.
Yes.
And I appreciate that. It seems to me, as I said, that you can speak with some authority then about farming and ranching concerns. And I'd like to go back to your opening statement, if I could. Something that you mentioned briefly, but I think it's worth coming back to. And that is your telling of what happened out in Tooele County, which is a fairly rural county in Utah. It's west of Salt Lake. It's a county that I represent, by the way. And you go back a few years, 2012, where we had agents from the Forest Service who were denying ranchers and farmers grazing permits unless they agreed to relinquish their private livestock water rights. Look, that to me is just unheard of, and it's egregious to think of the impacts that could have on these, what are almost every case, family farms and family ranches. And I just wondered if you would elaborate on that and maybe just ask, have you ever heard or seen an example of such what I consider an abuse of power?
This is as far as I've seen it, as aggressive as I've seen it based on the livestock industry. I think I want to start by noting that, like the ski industry, water is part of the balance sheet for livestock producers as well. It's part of the asset base that they borrow against. For that group in Tooele County, they initially were asked to sign a change of use application, which would have transferred the right to use that as livestock water to the federal agency, and then they would determine what they wanted to use it for. That's what a change of use application would allow. So they would turn over their ability to maintain that as livestock water on that allotment. The Forest Service objected and said, well, we made a mistake. We only wanted them to sign a joint ownership agreement. And we really didn't mean that they wouldn't be able to use their grazing allotment. Well, that's after the cow's out of the gate, so to speak. And either way you cut it, that's a diminishment or a relinquishment of value and of a right that's granted under the sovereign rights of the state of Utah through the state engineer. It's a taking. There's no question about it.
There's no question. I mean, I may own my home, but if someone demands joint ownership agreement of my home, that's a substantial reduction of my rights in private property. Can you tell us very quickly, how was that resolved? What was the outcome of that?
The regional forester intervened and said, we really didn't mean to go there, and so they've kind of backed away from it at this point. But my view is what happens with the ski industry will be a telltale sign of how much further this creep could get into the livestock industry. Livestock water are across the state of Utah, the second most arid state in the nation. If we don't have that broadly dispersed water for those livestock to graze out there on those rangelands, the grazing value is gone, as is the water value.
Well, and so in this case, maybe they backed off a little, although they haven't backed off entirely on this. It hasn't been closed. But we know that there's instances in Nevada, for example, where BLM and Forest Service agents ended up, some of them, in criminal charges and actually going to jail for
in the Hage case, yes, absolutely.
Yeah.
They overfiled on their water. It went to court. The Supreme Court wouldn't hear it because they said it isn't right. But yes, that's where we've been.
That's exactly right. And so I see my time is up, but just very quickly, Mr. Chairman, look, when you have federal agents that are acting in direct conflict of the law, and they're doing what I consider extorting something as precious as water rights out of private citizens, well, how would we expect those citizens to react? How would we expect them not to have some, to have this?
We'll take that as a rhetorical question, but
yes,
there has been a request for a second round, so we'll get back to that.
Okay, thank you. Yes, I'm going to be very brief. You all have been patient with us as we delayed for the vote, and it's getting late, and so I won't take but a few minutes. But I want to pursue what Mr. Tipton was saying and maybe draw some conclusions from it. Let's, for the moment, give the Forest Service or BLM agents the benefit of the doubt. Let's suppose that they have reasons for some of the things that they've done, or at least that they had some objective that they were trying to achieve. And I would ask maybe Mr. Corbin, or again, my friend Mr. Parker, have they explained to you what it is that they're hoping? Why is it that they would exert these rights when it would be contrary to tradition and law?
The argument that they've made from a livestock standpoint is they suggest that that's the way they can assure that it will be there in the future to maintain their multiple use obligation and allow grazing. But we've already made that happen in Utah under state statute. Yep. We've made livestock water rights pertinent to the land. I
think that's exactly right. Their desire to tie that water to the land. And I'm going to come back to that. Mr. Corbin, did you want to add to that?
I would agree, and the same rationale has been given to us, that the stated purpose is to have the water available for the special use permit and the ski area per se. But as has been testified here already, in the rule that was proposed in 2012, there really wasn't such a restriction. It was indeed contemplated that uses might be other than skiing and outside of our permit areas for other purposes, whether that's aquatic systems elsewhere or not.
Whatever it might be.
Could be anything.
That's right. Which brings me to the point I'd like to make on that, and that is, while they wanted to ensure that the land and the water were tied so that it would continue to be used for the purpose that it was being used, they were afraid essentially that the water rights would be sold downstream for other uses or for some other cause. But we asked, not myself, I wasn't in Congress at the time, but the Congress asked the chief if he had any examples, even one, of that occurring. And this was several years ago, and his answer was no. We don't have a single occurrence where that has been actually what took place. And I'm wondering, in the ensuing 2 or 3 years since then, are either you aware of any example of that occurring?
In my experience, no, sir. I'm not aware of any ski area that's essentially stripped itself of its water and sold it.
Of course not.
As
of course they wouldn't.
It would severely hamper your ongoing enterprise. So
yeah.
there's no real reason to strip your water off of your ski area.
No self-interest of you doing that, Mr. Parker. Do you?
And if you take where livestock water is across Utah in particular, it's been developed out there across the landscape, and it's an arid landscape, and a lot of them are just troughs where seeps have been run into it for water for livestock and wildlife. It would be impossible to be able to transfer that dispersed water out there across the Utah landscape, put it into a pipe and send it to some municipality.
Yeah.
It can't happen.
Practically.
The best use of it is livestock water for the economic opportunities that it affords rural Utah.
Yeah. Well, and so I started out my questions to you by saying, let's give the agents the benefit of the doubt, try and understand why they're doing this, but their own reason, their justification, it's chasing a ghost. I mean, they're trying to solve a problem that doesn't exist. What they're trying to do is to preclude a problem that, by their own admission, does not exist.
If you look at the findings in the Hage case, particularly when the federal government, the agents filed a trespass suit against the family, It's not, the agencies are strong-arming these individuals out of being able to clean their ditches, out of using their water right. These are federal agents that by court were fined for illegal activities against those ranching families. Very few of them have the financial wherewithal to do this. The Hages did, and they found a pretty tough treading to go through the court system.
Yeah. Well, thank you again to all of the witnesses. You've helped me make some important points with your experience. And Mr. Chairman, I yield back.